All right, praise God. All right, so I'm going to go ahead and mute myself, and Bishop Ward, you're on, and I'll hit the top.
Okay, thank you, Mr. Prim. Good evening, Jekyll. How are you today?
I'm well, Bishop. You?
I'm doing fine. I'm glad to meet you and have you a part of our first Zoom conference. And we're just going to give you some questions so that you can try to let us know a little bit more about you. So start by telling us a little bit about yourself. How long you've been on the bench and what you've been doing.
Been on the bench for 9.5 years, and that was following 31 years in private practice and 4 years as a high school teacher. I went to law school at night. Since on the bench, doing those things that judges do, but probably the thing that I've enjoyed the most in the last 5 years is becoming one of the 5 mental health court judges, mental health and developmental disability. It has opened up a whole new area for me and learned a great deal, and actually feel this is one area where we can actually help people. And we're not just giving out sentences or probation, and there still is probation with the mental health, but it's one of the areas that I really feel like we're doing something positive.
Okay. But how have you, since you've been on the bench, how have you helped right the wrongs of a flawed criminal justice system that has preyed upon poor people and minorities?
Well, first of all, trying to do the right things with the cases that come before me and evaluate those cases individually based on what is presented to me. Tried to be much more flexible, and especially more recently with the bond issues in terms of people being out who shouldn't be in, and tried also to look at you want to look at the least restrictive means in terms of what you're going to do in terms of sentencing. I mean, there's, probation department does a good job, and if we can get people on probation, all the better. And one thing we've just realized because of this COVID, and we used to drag people down on a weekly basis to show up for pretrials, which really would mess up guys who are working. It was a burden on them, people with trouble with transportation. And what we found out now is we can do it all by telephone or by Zoom. We don't need to bring people down unless there's an event, if we're there for some sort of a hearing, if it's time for a plea to take place. So those are things you try to do as well. You may or may not be aware that Judge Ron Adrien, some years ago, probably back when I took the bench, instituted with the Ohio Supreme Court a program called the Equal Access to Justice. And the idea of that program, and it's a requirement for all new judges, and it's repeated for us in terms of continuing legal education. But the idea of the equal access to justice is just what it says: to become much more aware of who you're dealing with, how you're dealing with them. Is there some sort of inequity in terms of how you're dealing with those folks that are before you? To be much more aware of what's going on. And our court in Cuyahoga County has tried to pick up on that, where we've had some diversity training. We've had situations where we've been asked to see certain films or movies like the Central Park 5, and then have a discussion group with folks in the court about those kinds of things. So there's been a move to try to be much more aware and attentive to being fair and equitable with all the people around you.
What new and different perspective have you brought to the court since you've been a part of it?
Well, I didn't come from a criminal background. I was a civil lawyer. And so I came in with sort of an open mind in terms of what am I dealing with? How do I handle these cases? Make sure I follow, you don't worry about constitutional rights a whole lot when you're a civil lawyer. So make sure those constitutional rights are taken care of. So that perspective, I think, came in a little differently than people who have been prosecutors and spent their career doing that, because that's not my point of view. I mean, the other thing that I think you'd understand very well, when you're a civil lawyer, all you're talking about is money. When you're talking about a criminal case, you're talking about somebody's liberty and about their life. And, that's a whole lot different than getting a check for a car accident. So I think coming in with a perspective from that point of view, and then I had 31 years in private practice. So I wasn't a kid coming on the bench. I was 58 years old. And so I think I'm sure you understand, Bishop, about, you learn some things just by being around and having that age. And you understand. I mean, I've got, between my wife and I, we have 6 kids, and I have to correct my resume. I just got a 6th grandchild. But you know, in terms of growing up, raising children, seeing what happens, there's no kid in the world that doesn't get in some sort of a scrape, and dealing with those kind of things. So I think, you know, my age, my civil background brought a perspective that was a little more open-minded than it might be for other people.
So what since your background was in civil litigation, how have you been doing now with the criminal litigation as well?
I think I'm doing well. I mean, I think you'll see, and if you were to talk with some of the criminal defense lawyers, and even some of the prosecutors, give you an example. I get a lot of bench trials. You don't get a lot of bench trials in a criminal case unless the people before you think you're going to be fair. So I've had a fair number of criminal bench trials. You know, initially when you come on the bench, everybody's trying you out. What's this guy like? What's he going to do? So I've had a number of bench trials. So I think that speaks volumes about how I approach things. Look at, I'll give you, I always tell people, like on evidence rulings. In a criminal case, in case there's a question on the evidence ruling, to me, it goes in favor of the defendant. In a civil case, it goes on behalf of the plaintiff. They've got the burden of proof. But if it's a 50-50 call, I think the break should go to those two sides, because they're in the much tougher position. So try to be extremely fair, try to get people the chance to present their cases fully. I do not rush people on the docket. I don't make cases move super fast. I'm not trying to keep people from getting their day in court, but I'm also not trying to shove them through where they don't have a chance to properly evaluate their case and understand what they're facing.
So what is your opinion on pro se litigants? Do you think you can fairly adjudicate, or have you fairly adjudicated cases where you have pro se litigants?
Yes, they're difficult. They can be difficult, the pro se litigants. We try as hard as possible to suggest to them to have assigned counsel if they're indigent. If you always have what we call shadow counsel for pro se litigants. So they have an attorney there to help them and guide them through some things, but the attorney can't really take over. And I've had pro se in both civil and criminal, but obviously the criminal is the far more important. And it's, you know, you wouldn't want me getting up giving a sermon in your church. So it's not in their best interest for them to get up and try to represent themselves. I mean, they can do it, and I've had people who do it pretty ably, but generally they end up making mistakes, often end up testifying when they have a Fifth Amendment right not to testify against themselves. And you try to give them all those warnings, and they just can't, you know, they really can't help themselves. It's that old, you know, quote I'm sure you've heard about, he who represents himself as a fool for a client.
Yes, I am. Okay. How would you hold and I'm wondering, have you had this opportunity? Have you had the opportunity to hold peace officers to the same standard of law as a common citizen?
Yes, I've had trials I've had one as a bench trial involving a police officer. It was a gentleman in Parma this was the partner of a gentleman in Parma who ended up getting killed, Daniel Ficker. You may be familiar with the case, but it was an odd circumstance, and they cited him with a second-degree misdemeanor dereliction of duty. They never indicted the officer who had actually had the gun that went off and ended up killing this young man. But I've had that. I've had many of the people on the stand, and you can tell real quickly those folks that are telling you the truth and those that are trying to just get a conviction.
What do you perceive as the greatest obstacle in the justice division where you're presiding as a common pleas judge?
Probably the biggest problem I see is to make sure that people all get good, full, fair representation. You know, we have something like 270 lawyers on the assigned counsel list. There are some great ones on there, but there are some that just mail it in. And you can see that happening sometimes on a plea where the person hasn't met in advance, hasn't gotten the information, and they're trying to be forced into a plea. And you can't do that to somebody. Now, it may end up in the final analysis that it's a good deal, but you can't just come in a minute and a half before you walk in the courtroom and say to this guy, hey, take this plea. That's not right. So making sure they get good representation, because there's lawyers and there's lawyers, and you often hear the same names, probably 30 or 40 lawyers over and over again, and that's because they're the ones that do the job, that do a fair job and represent people fully. And I think that's probably the biggest problem in terms of defendants getting their representation.
With your being on the bench and having a background and a history in being on the bench, what is your vision for the future of our judicial system here in Cleveland and Cuyahoga County?
We need to improve ways of keeping people out of the criminal justice system. And the example I want to tell you about, we flew down to Florida. There's an unbelievable judge named Leafman down in Miami-Dade County, and he's been a real pioneer in the area of mental health. He's got a system down there, at least in the misdemeanor court, where they have a pre-charge diversion program. So if this person maybe has some sort of a psychotic breakdown and is arrested, they often take him to a crisis intervention center. And then they say, look, if you'll sign this deal and work with us for 9 months, a year, and be successful, we'll never charge you. And in their felony court, if they're successful, they dismiss the charges at the end of the time they do that. We need more of those kinds of diversion programs. We need more programs so that people don't have records, so they don't have a felony that's going to hurt them in employment in the future. I mean, if there's a serious crime, okay, you got to deal with it. But a lot of these things are minor crimes that now become an indelible mark on somebody's record because of one little mistake he makes. So I think we need to do more ways of diverting people out of the system. And then I think our probation department does a really good job, but we need more ways of making sure people don't come back. I don't want to see a guy again unless he's on my jury. I don't want to see him with new charges. So better ways of getting people out of that system and helping them any way we can. I mean, there's a lot of good programs, and there are a lot of agencies, especially with this mental health. We work with the Centers for Children, Signature Health, Recovery Resources, Metro Hospital, Frontline for the homeless. They do unbelievable work to help these people, and the folks that get on the system and work with it are very successful.
So to piggyback on that question, what changes would you advocate, and why would you advocate for those changes?
Well, stronger diversion programs, more where the judges can control the diversion program. Now, there are certain ones that I can approve over the objection of the prosecution. There are others where the prosecutor has to agree with the diversion program. And I'm not saying that Mr. O'Malley necessarily is difficult about that. That's not what I'm saying. And I think some of that is statutory. So it's not as if he made the rule is out there. But I think if we can give a little more discretion to allow us to say, I really think this is somebody who ought to be in diversion, give him a chance, let's try it, and then be able to be successful in doing that. I think that's the way we go about it. We got to push more to have the judges get the training, the diversity training, to get the equal access to justice training, to be much more mindful of who's in front of them and understanding those people. We get great pre-sentence investigation reports that tell us all about what's happened in this person's lifetime. You probably are aware that there's unbelievable trauma for people in their lifetime. I mean, they didn't get in front of us just because of nothing. There are reasons that they got there. So we've got to recognize those kinds of traumas. What can we do to help them get past that? So all of those kind of things, we need much more attention to that. This isn't making a product. You're not making widgets here. You're dealing with people in their lives, and you got to be attentive to that.
So since you've been on the bench, how have you used your position of being on the bench to bring about important changes to the judicial system in this county? And especially those that disproportionately affect people of color.
What you're trying to, the problem as a judge is you're limited in terms of what you can do. Obviously, among the judges on the bench, trying to make sure that we work together, talk about these things, try to work toward a common way of dealing with it. There's kind of a joke in the courthouse. We have 34 judges and 42 personalities. So it's difficult. It's difficult to get everybody on board. And if I were to tell a colleague, well, this kind of case, the guy should always get probation. Some of them might agree with me and some of them are not going to agree. So we try to collaborate as much as possible, try to lead by example. Hopefully what I'm doing with my cases and with my mental health cases sets an example for what it makes sense, and it's been successful. So what has been successful? Gee, if it's working, why wouldn't you want to follow that?
Thank you, Judge McClelland. Is there anything you'd like to close with? Those are all the questions that I have. Anything you'd like to share with us as you give some final thoughts?
Well, I'd like to say a couple of things. One is I really appreciate you doing this. You're taking a lot of time out of your lives to do something that I think is important. And I think it's important for voters to have more information. We're on the bottom of the ballot. We're not the big superstars like the presidents and the senators and the Congress people. And I always say when I'm on the stump, there's a better chance you're going to see me than you're going to see the president or a congressman or a senator. And you got to think carefully about who you put on the bench, because you get, unfortunately, you may be stuck with a life and death decision or a multi-million-dollar lawsuit. So it's important for people to know about that. It's also important for them to hear from different communities. And you're adding a perspective, a different perspective than other groups. So and I know it's a time-consuming event. So I really appreciate the opportunity to meet all of you, to talk with all of you, and to have a chance to ask you, to endorse me, to rate me highly. I think I wasn't opposed in 14. I mean, that should tell you something. I've got 13 unions endorsing me at this point. That might tell you something. So I think I've done a good job. I think you feel funny being boastful, but I think I'm doing a good job as a judge. I think long and hard about what I do. I have some sleepless nights. There are those. It's the hardest part of the job by far is sentencing people. But I really appreciate what you're doing. I look forward to it. If I can do anything more or provide you with more information, I'd be more than happy to do that.
Judge McClelland, thank you so much for participating in our first Zoom conference, as well as our rating and endorsement process. God bless you, and thank you so much.
Thank you all. Good night.
Good night. All righty. So for the NAACP, you rate him. For GPAC, Pastor, if you, I know we got a